Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Coming to you from Washington's nicest indoor shooting facility. Of course, that's Security Gun Club right here in Woodinville, Washington. Now, listen, I'm a little late getting to the party on this one. There was a huge ruling that came out about a week ago as it relates to force reset triggers and Operation Reticent Recall. A lot of other people out here in the YouTuberverse got videos out there. I had an opportunity to review that. I had an opportunity to review the actual order of the court. I think this is a really beneficial ruling, but I want to caution you on what the affect and what the remedy is for most of you. So today, let's get everyone educated and let's talk about this trigger ruling is big, but how big? Okay, so the case we're talking about today, and we have talked about this case before, is National Association for Gun Rights v. Garland. This is a case that's filed in the United States District Court for the Northern District of Texas in the Fort Worth Division. This is a challenge to ATF's Operation Reticent Recall. For those of you who don't know what that is, that's when the ATF woke up one morning and decided that they would redefine force reset triggers and wide open triggers standing alone, the trigger standing alone, to constitute a machine gun, and then go on a confiscation effort around the country, threatening lawful owners of these devices, purchased completely lawfully, with, of course, arrest and possible prosecution. There has been a couple of other lawsuits related to this, but what we got from the court last week was an injunction against the ATF from enforcing Operation Reticent Recall. Now, my concern is that I saw a couple of other videos that suggested that means all of us, we're going to no longer live under the dark clouds of Operation Reticent Recall. Not entirely true. The court order actually spells that out. What I want to do is kind of get through the opinion so you can understand, because is there a lot of positives to take from this? Yes, there is. Is this a really good sign for where this litigation is going? It most definitely is. Does it give you the needed relief that you need right now? Probably not. Now, as we know with many of these ATF actions, what's actually striking them down is their violation of the Administrative Procedure Act, that they have, shockingly in this case, the ATF has exceeded their statutory scope and done things that were outside their lawful authority. Sound familiar? As the court ruled in this case, the Administrative Procedure Act instructs the court to hold unlawful and set aside agency action found to be in excess of statutory jurisdiction, authority, or limitations. Plaintiffs contend that the ATF's regulation broadening the machine gun definition is an arbitrary and capricious expansion of the agency's authority. Plaintiffs are likely correct. And ultimately, what this case, and every case involving Operation Reticent Recall as it relates to the force reset triggers and the wide open triggers is do they even fall under the definition of a machine gun? Because let us remember, a machine gun is a firearm which will discharge multiple rounds per single function of a trigger. However, as we know with forced reset trigger technology, as well as wide open trigger technology, that the trigger is actually activated for each round which is discharged. There is multiple functions of a trigger if multiple rounds have been discharged. And that analysis is not unique because, well, it's already been done by a court. Because let us also remember the case of Cargill v. Garland. Now, that was a challenge to ATF's ban of bump stocks because, again, the ATF basically stepped in and said, well, bump stocks standing alone constitute machine guns, and therefore we're going to ban them under the NFA. In throwing out that bump stock ban, however, the Cargill court clearly found that bump stocks just don't fall under the definition of machine guns, and therefore the ATF had no authority to ban them, much as the same case here, as the court pointed out. The Fifth Circuit's recent analysis of the exact statutory language at issue here shows that plaintiffs are very likely to succeed on the merits. The National Firearms Act unambiguously requires that a machine gun be capable of firing automatically once the trigger performs a single function. By comparison, the statutory definition does not define machine guns according to how quickly they fire. To qualify as a machine gun under the statute, a weapon must only be capable of firing automatically once the trigger itself performs a single function. And that's really important. In my state, in the People's Republic of Washington here, we actually define automatic weapons based upon rate of fire and not the functionality of the trigger. Now, this analysis is so thorough, this case law is so thorough, that the United States government essentially didn't even try to rebut it. Well, they did put one little footnote where they basically just said, or as the court pointed out, defendants offer almost no rebuttal to the holding of Cargill controlling here. In fact, their response is relegated to a single footnote. This lone footnote contains the conclusory statement that plaintiffs, quote, have not carried their burden of demonstrating a substantial likelihood of success on the merits of their claim. And of course, if you're losing on the likelihood of prevailing, what else could the government do? Well, the government could say, hey, listen, there's no harm, no foul. No one's like they're really getting prosecuted for this. So there is no irreparable harm. But at the same breath, this is the agency that is also saying, yes, we are going to continue to pursue Operation Reticent Recall. They continue to send letters out there, and those letters threaten each and every one of those lawful owners with what? That's right, prosecution, as the court pointed out. First, plaintiffs face a credible threat of criminal prosecution. As explained earlier in this opinion, plaintiffs place themselves in potential jeopardy by bringing this challenge to the ATF's regulation of FRTs. Defendants' recent enforcement activity validates those fears. Armed FBI agents visited Plaintiff Kerry at his home, prompting him to surrender his FRTs to avoid prosecution. Finding that plaintiffs face a credible threat of civil or criminal prosecution for prior and current ownership of FRTs, the court further finds that this constitutes more than de minimis harm, justifying the need for equitable protection. Now, this is the part I want everyone to be clear on. Yes, the court has issued an injunction. Does that injunction cover everybody in the United States that could be subject to an Operation Reticent Recall letter? No, it doesn't. Does it at least protect all the people who lie within that jurisdiction? No, it doesn't. It protects only the named plaintiffs. The order of the court is very clear. It states as follows. Thus, the court enjoins defendants from implementing or enforcing the ATF's expanded definition of machine gun that prescribes FRT possession against these individual plaintiffs. This TRO protects only the individual plaintiffs from civil or criminal enforcement of the challenge rule during the life of the TRO. Other unnamed individual members of the institutional plaintiffs are not covered under this TRO. So what the court is clearly saying here is unless you are one of the individually named plaintiffs and not just a member of NAGR, they are the only ones that will enjoy the benefits of this restraining order. So if you are a member of National Association for Gun Rights, congratulations, it is a fantastic organization. Do I believe you're getting injunctive relief due to your membership? Not on this one. Do I believe that National Association for Gun Rights should be commended for their litigation? Yeah, they do, and we're going to put a link for them down below so you guys can show them some love. The case, once again, is National Association for Gun Rights v. Garland. We'll link that down below so you can geek out on it as well. Obviously, there will be more developments, and we will be sure to let you know. In the meantime, if you guys got any questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. If you don't, that's okay. That information is also down in the description box. Now, in the meantime, let's remember that part of being a lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.